Hello, GOPO children. This is Master Instructor Chairman General Thorson coming to you live from Bunker 167. Today we're going to finish the rest of Chapter 4 and talk about the 4th through the 8th Amendments, or the rights of the accused or the rights of the defended. Let's get started. The amendments we're going to look at today are Amendments 4, 5, 6, 7, and 8. These are rights or civil liberties that we get that basically protect defendants or the rights of the accused. When it comes to interpreting defendants' rights, basically criminal justice personnel, people who are in charge of arresting and putting people away in prison for committing crimes, they are limited by the Bill of Rights. And if they fail to follow these, a court decision can be invalidated and a criminal could go free, or an accused person could go free based on technicalities. So courts, whenever they make decisions, they're making decisions on what is constitutional and what is not.
It's the sound of my gun. What have you done? It's the sound.
Before we get into the rights of the accused, let's talk about the Second Amendment, the right to bear arms, a very controversial amendment. Still, there's much debate over it today. But pretty much here's what is allowed for the most part under the Second Amendment. Now keep in mind that states differ on what they allow specifically, but for the most part, this is what is allowed. There are restrictions on owning and carrying handguns. Most states let you carry a concealed weapon. Illinois is one of the few states that doesn't. You have to have a background check in order to get a gun. Usually it takes about 72 hours to process, and you have to be in Illinois 18 years old to get one. There are a limited amount of guns that are allowed to be sold. For instance, certain automatic weapons are not allowed to be sold, or ones, that are more advanced that typically are used in the military aren't allowed to be sold. For instance, like an AK-47. A lot of states don't let automatic weapons like that be sold. Also, when people have guns, they're required to store it in a certain fashion, not only to keep people from robbing them, so that people without licenses have guns, but also to keep children safe from being around them. Courts usually uphold all of these things, but like I said, this is an example of federalism. Each state kind of decides how strict or not as strict they will be with guns. Heller's got a gun. Heller's got a gun. District of Columbia versus Heller. Who's got a gun? What did the court case say? To have a gun, it's okay, as long as you use it for self-defense in your home. They said that even though the Second Amendment says you can't have a gun unless it is for state militias. But this one said it doesn't matter if you have a gun. So now Heller's got a gun. And if you have some background checks, you can have a gun. But make sure that you're 18. Has the Second Amendment been incorporated to the states? No, and this one was strictly for DC, but it basically set a precedent, not an official precedent for the rest of the states to follow, but a precedent nonetheless. And most likely because of that, someone will question it, and eventually this right will be incorporated into the states. Here, let's talk about defendant rights. It's broken down into stages. It's not necessarily in order of the Constitution, but here are the protections that you get under the Constitution. First of all, when evidence is being gathered on anything that you're involved in a case for, it can't be unlawfully gathered. It cannot. It is not allowed to have unreasonable searches and seizures according to the Fourth Amendment. Next, suspicion cash. You cannot be arrested and just thrown in jail without due process. That is according to the writ of habeas corpus, which is Article 1, Section 9, something Congress and the government is forbidden to do. Habeas corpus is your right to due process in a fair, speedy public trial. Once the arrest is made, you have the right to counsel. That is the Sixth Amendment. When the interrogation is held, you have the right to not self-incriminate or to plead the Fifth, meaning you do not have to talk against yourself. That's the word I'm looking for. Excessive bail is forbidden. If you're arrested for, burglary, petty theft at a gas station or something, you can't have $1 million bail. It has to fit the crime. Trial held has to be fair, speedy, and public with an impartial jury, according to the Sixth Amendment. Double jeopardy is not allowed, meaning if you are found not guilty, you cannot be tried for the same crime twice. That is the Fifth Amendment. And trial by jury is required according to Article 3, Section 2, and you are allowed to confront witnesses that you choose, and that is the Sixth Amendment. Also, when the punishment is imposed, it cannot be cruel or unusual, and that is the Eighth Amendment, of course, if you get punished. All right, now we're going to look at the Fourth Amendment, no unreasonable searches and seizures. There's a few parts to this. Number one, officers of the law must have probable cause when they feel that a person is arrested. They can't just arrest you just because. So if you are arrested for no reason and they don't have probable cause, that evidence will be inadmissible in court. They cannot also be unreasonable searches and seizures. They can't search and take things in a haphazard or illegal way. They must follow what is in the Fourth Amendment, which means they need to have probable cause and a warrant. The exclusionary rule follows according to Mapp versus Ohio, which was a selective incorporation case where it took the Fourth Amendment and incorporated it at the state levels. If evidence is obtained illegally, no matter how incriminating it is not allowed to be used in a court of law. Now, I know you're probably thinking, okay, if I saw something that was very obvious, it was the gun that killed somebody, and I'm on the jury, and I can't use that, it's still going to be in the back of my head. Yes, that's true. But you just got to look at the list of what is allowed to be used, and that is how you can decide the case, even no matter how incriminating it might be. Now moving on to the Fifth Amendment, we're going to talk about self-incrimination, which is the idea that when an individual is accused of a crime, they do not have to witness against themselves. They do not have to confess to anything as long as it's dealing with themselves. So if they're put on the stand or if they're asked by the cops, what was your involvement with this, you can plead the Fifth. But if it was something like a burglary and they were asking, well, what was Joe Smith's involvement, your friend who got arrested, you would have to confess, or that would be considered withholding evidence from the police. And not only that, police must inform the suspects of these rights of no self-incrimination upon arrest, and if they don't, it can be used against them, and they could see any confessions that were made without their Miranda rights being read to them would be inadmissible in court. Again, that's the exclusionary rule. This was how this decision was made with the court case Miranda versus Arizona in 1966. Also, you are protected from coerced confessions. Coerced meaning forced into something you don't want to do, or entrapments where they try to trick you into doing something that you wouldn't necessarily do. Moving on to the Sixth Amendment, the right to a fair, speedy, and public trial. Make sure that you know those three things. The right to counsel. This goes along with the fair trial. In most criminal cases at the national and at the state level, people must be provided with counsel even if they can't afford it. This was decided in the case Gideon versus Wainwright, another example of selective incorporation. During trials, most of the time, about 90% of the time, cases don't go to trial. Typically, the defendant does what's called plea bargaining, where they will agree with the prosecution, the one working for the government, the plaintiff in the case. They will say, if you agree to a lesser crime and plead guilty to that now, we won't charge you or try to charge you with a greater crime in an actual court case. And like I said, 90% of the cases usually go through plea bargaining, don't actually make it to trial. But if they do make it to trial, you have to be tried by your peers. That is a public trial. It's not only can the public see it, but it's also you have to be tried by an impartial jury of 12 people. Most of the time, unanimity is required, but not all the time, meaning 12-0 vote in order to convict. The Sixth Amendment also guarantees that it's speedy and public. Like I said, not only is it fair, but is it anybody can see it, and it has to be done within 100 days of arrest, or you will be allowed to be free. Next, we're moving on to the Eighth Amendment, no cruel and unusual punishment and no excessive bail. And the big question is that people ask when they're looking at the Eighth Amendment is capital punishment cruel and unusual, meaning the death penalty? Well, according to Gregg versus Georgia in 1976, no, it is not. The death penalty is not cruel and unusual, and it is an extreme sanction suitable for the most extreme crimes. Usually they consider murder as being this crime that would deserve the death penalty, kind of an eye for an eye situation. Now, when it comes to the death penalty, here's another example of federalism. States get to choose whether or not they are going to enforce the death penalty. Illinois, for example, used to have the death penalty, but once Pat Quinn got into office, he abolished it from the state of Illinois. Now, let's look at the right to privacy. This is not explicitly said or listed in the Constitution as one of our personal liberties, but the question is, do we have the freedom of a private personal life away from the intrusion of government? And like I said, even though it's not explicitly said in the first 10 amendments, it is implied in both the Fourth Amendment and the Ninth Amendment. In the case of Griswold versus Connecticut, a case about birth control, said that women do have the right to take it because they have the right to privacy, according to the Fourth and Ninth Amendments. The right to privacy was again questioned with the case and controversy of abortion. In 1973, the court decided in the court case Roe versus Wade that abortion is constitutional according to the Ninth Amendment and the right to privacy. Now, what they said was in the first trimester, it's completely the woman's decision. In the second one, it has to be the decision of the woman and the doctor. In the third trimester, they're not allowed to have an abortion. This case was called into question again in Planned Parenthood versus Casey in 1992. And the question was, in the state of Pennsylvania, they made it where if you were going to have an abortion, you had to have permission if you're a minor from a parent, or consent from your husband if you're married, and you had to wait 24 hours to get one. So the question was, is that unconstitutional? And the court, in a bitter 5-4 battle, upheld Roe versus Wade, and said, yes, they are allowed to have the right to privacy. What Pennsylvania was doing was unconstitutional. So this was, again, to protect those that are trying to seek an abortion. There are rights to protesters. There are people who protest against this, usually outside Planned Parenthood buildings. In other places, a lot of times you'll see it on college campuses. But that just goes back to the First Amendment. And if you look at this chart, this is the abortion debate, whether or not how people feel about it. Most of the people feel like it should be legal under certain circumstances, meaning that most people believe, yeah, it's okay as long as it's for good reasons and in most circumstances, but not all circumstances. We need to understand how civil liberties work in the scope of government and also in our democracy. When it comes to democracy, rights ensured in the Bill of Rights are absolutely essential to democracy because we the people rule, and we the people should have these certain protections. Courts typically favor and rule in favor of protecting civil liberty over majority rule. What does that mean? That basically means, and I've told you this before, that they rule to protect unpopular things, not the popular things. Also, when it comes to the scope of government, how big or small do civil liberties make the government? Well, in deciding between freedom and order, again, the United States definitely chooses liberty, meaning that they protect the unpopular things. And they really do limit the scope of government. It doesn't allow it to do whatever they want. It actually forces them to stay within certain boundaries of what people can and cannot do, because these are our rights that are protected from the government. So they aren't allowed to touch us, therefore it makes them smaller. So what's the moral of the story with Chapter 4 and civil liberties? Well, first of all, civil liberties are found in the Bill of Rights, specifically in Rights 1 through 9, and then eventually in Right 14, Amendment number 14. Also, what are civil liberties? These are our protections against the government, like freedom of religion, expression, our right to be accused, our rights to assemble, for instance, our right to privacy as well. Also, these amendments, these liberties that we have, are very vague, and they're line a very, very gray area. So constantly the legislatures and courts are basically defining what these liberties that we have are. So I hope you enjoyed this. I'm Mrs. Thorson. Have a good night. Forge out.